Welcome. Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. I'm a professor at Mississippi College School of Law. But I tell you the name of my school only for identification purposes. All views expressed here, all interpretations are my own. This series is for all of us. It's for all of us who are seeking to have more learning and enlightenment about the Constitution. And it's for my students who I am teaching remotely, and they are currently enrolled in my constitutional law course and my civil rights lawsuits course. So this clip is going to be on constitutional law. Now, this is the first clip we're going to do on privacy rights, and it's designed to help encourage you to take a soak in the law, not a quick shower in the law, but a soak in the law. You know my theory. The more we know about the Constitution, the better we can then work and advocate and argue and debate to help the Constitution and this country to live up to the promises of the preamble. And one of the promises is to deliver justice. Now let's get right to it. So if we talk about, you often hear people saying, especially today, that the government is invading their rights of privacy. But I ask you, where in the Constitution is this right of privacy? So if you have a Constitution, or you can Google later and take a look online at one, take a look at the first 10 amendments, the amendments to the Constitution. And you will see that certain rights are expressly stated in the Bill of Rights. You'll see the First Amendment. The First Amendment refers to the right of speech or freedom of expression, religion rights, the right to assembly, the right to petition the government for redress, etc. The First Amendment. You'll see the Second Amendment. The Second Amendment speaks to the right to bear arms. You'll see other rights that are applicable to those who are criminally accused or criminally charged. You go on, you'll see equal protection, you'll see due process, etc. But I challenge you, read those first 10 amendments. You will nowhere in those amendments find the right of privacy expressly stated. Now, some justices say it's not there. And since it is not stated in the text of the amendments to the Constitution, it doesn't really exist. And therefore, government can intrude on this asserted right of privacy with the lowest level of review, rational basis. Now, if I lost you on that point, you need to go back and look at the earlier clip where I talk about the levels of review. And the court has determined that ordinarily, all government has to show is a low-level rational basis. The court scrutinizes government more, a heightened review when fundamental rights are at issue, certain actions by government are directed at certain non-majority groups. So where is this fundamental right? Some justices say it's not there, but few of us probably agree with that. Most of the justices have said, oh no, there is a right of privacy. You may not see privacy in the first 10 amendments, but it is there. So the question is, where does the court get it from? Where does the court see it? Now, this is the explanation that is given. See how you like this. So have you ever I'm sure you've been outside when you're a child. You probably played games where your shadow, and maybe someone would try to step on your shadow. So the court says that the right of privacy is there. It's there in the shadows of other rights. In other words, the court says, all right, you got a First Amendment right here. You got a second, you got a third, you got a Fourth Amendment right, Fifth Amendment right, Ninth Amendment rights, what have you. All of those rights are there. They're expressly there in the Constitution. But those rights throw out shadows, penumbras, zones of privacy that emanate from those stated rights. And that's where you find the right of privacy. Now, I know you think I'm making this up. I am not. This is what the court has held, that the right of privacy is there, and it's there in the penumbras or the shadows of the other rights. And when we get to the next clip, I'm going to actually give you the names of some of those cases so you can go back and check me and see if I'm right on this. You know, part of learning is to explore and to learn on your own. So I'm not afraid. You go check me on this point because I know what the court has held on this. Now, so the problem with this, which you have these defined rights given out their shadows, the problem becomes what is there in this shadowy penumbra of privacy rights and what is not. What is there? If it's there, then the court should scrutinize government very carefully when government intrudes on those rights. But if it's on the outside of the penumbra, government can intrude with a very low level, with rational basis. It just has to be reasonable, doesn't have to be wise. But if the right is within this shadowy penumbra, then the court is going to scrutinize government more when government steps and invades into that penumbra of expressed rights. Okay, let me give you some hypotheticals I want you to think about. These hypotheticals come from actual cases. So I just want you to think about, should these things be included in the shadowy penumbra of rights? Or are they things, are they on the outside, which means government should be allowed to more freely regulate? Or are these things in the zone of privacy in this penumbra? I know it looks like I'm doing a magic show, but I'm not. I'm talking about the shadowy penumbra that the court has said, where we find our privacy rights coming out from the other express rights that are noted in the text of the amendments to the Constitution. Okay, so let's say that a state, let's say the state of Connecticut, they say, it's these married couples are using birth control, and that is not good. Because if the married couples are using birth control, that may encourage them to cheat on their spouses. And we don't want that. So therefore, we're going to make it unlawful for a doctor to prescribe or distribute birth control to married people. So my question is, can Connecticut do that? If Connecticut did it just intrude on married people's rights of privacy? Think on that one. Let me give you another one. Let's say that it's determined that married people ought to have the right to use birth control if they want as a part of their intimate relationship with their marriage. So then the single people say, hey, what's up with that? If married folks have the right to use birth control, then the unmarried people argue they too ought to have the right to use birth control if they choose. And let's say the state of Massachusetts wants to criminally convict some unmarried persons, some single persons who have been using contraceptives. Can the state of Massachusetts do that? Or do the unmarried couples have a right within that privacy penumbra to allow them to use contraceptives if they want, even if they're unmarried? Okay, let me give you another one. Let's say that there's a grandmother. A grandmother's living in the house. There have been some things that happen in the family. Some people have passed away. And so now the grandmother lives in her home, and in her house with her is an adult son and his son. Also in the house with her is another grandson of one of her other children who have passed away. Can they all live in the house together? What if the city, we'll just say Cleveland, Ohio, decides, no, you can't do that. In our city, we want to promote the nuclear family. The family should consist of a husband and a wife and, a couple of children and the pets. We do not want this other kind of family system within the community. Now, can the city do that? Or if the city does that, has it intruded on the grandmother's right of privacy? Does the zone of privacy include the grandmother's right to live in non-nuclear, a non-traditional for some types of families? Okay, you're gonna think about that one. Let me give you another one. What about a woman's right to terminate a pregnancy or to choose an abortion? Is that right within this penumbra of privacy rights? What if a state wants to prevent her from having an abortion, criminalize it, or if the state says, okay, before you can have an abortion, you must get the consent, the written consent perhaps, of your husband? Does a woman have a right within that penumbra of privacy to have an abortion, or to have an abortion without the consent of her husband? Is her right within the right of privacy? So let me give you one more. What about consensual same-sex relationships, same-sex intimacy? Is that a right within the penumbra of privacy rights? What about same-sex marriage? Is that a right within the penumbra of privacy rights? It's not expressly stated in the Bill of Rights, but does it exist within the penumbra of privacy rights? I'm going to give you one more. What about the right of a couple to have an interracial marriage? And what if the state of Virginia says, oh no, people of color can marry each other in different races, but the state of Virginia makes it unlawful for a white person to be married to a Black person or a person of color. So does this couple who gets married somewhere else, do they have a right to live in Virginia as husband and wife? Is that right within the penumbra of privacy? And if it is not, then the state can regulate it with a rational basis. And here the state says it's trying to preserve the integrity of the white race. Let me give you another one. What about a right to refuse medical treatment? Let's say the doctor wants you to have a procedure or to take certain medication and you do not want to. Do you have a privacy right to refuse to do that? Let's go a step further. Let's say that a person has a terminal illness. Within the penumbra, is there the right to receive hospice care that may, in fact, with some of the medications, well, may in fact make them more comfortable, but possibly could hasten their death? Let's go further. Does a person have a right, a privacy right, to commit suicide or to commit suicide with the assistance of a physician if they have a terminal illness? So currently in our society, we're debating a lot about what rights are included in privacy rights. Now, with all of those different rights and the shadows that I just pitched out to you as hypotheticals, likely there are some that you say, I want these, but you may say, I don't want those included. The problem becomes this shadowy penumbra. If you start to eliminate some of the rights, could it possibly narrow the penumbra in a way that it also eliminates the privacy rights that you want? Remember, justice, you have to wonder, is it just for us, or does it respect the privacy rights of others? So in all of those hypotheticals I pitched, they weren't made up. They're actual cases the court addressed. And in our next clip, I'm going to give you the answers, some quick answers to how the court so ruled. So for those of you enrolled in my common law class, this is the point where you go and read, just read the 40 pages that were assigned, only 40 and 30 more for the next class meeting. And for the rest of you, stay tuned or click over for the next video that will tell you how the court ruled in those cases. And you can see whether you agree with the court or not. Again, this is a taste of justice. Make sure that you subscribe so you'll know when I'm posting these. I've been away for about a week with my courses. So sign up, subscribe, sign up for the notifications. And remember, our goal here is to learn and to think in line with our Constitution so that we can achieve more knowledge and just more enlightenment so that we can live up more to the promises made in that preamble. Again, A Taste of Justice with Professor Angela Mae Kupenda. See you later. Bye-bye. Gotta click it off. Okay, right here.